morning, everyone, and welcome to today's webinar on unfair contract terms. My name is Preetha Iyer. I work in the marketing team here at NatRoad, and I'll be your moderator. Speakers for today include Richard Calver, who is a Compliance and Workplace Relations Advisor at NatRoad, Alexander Sautel from NTI, and Tim Wedlock from AEI Transport Insurance Brokers. They will be talking about unfair contract terms with a focus on insurance requirements in transport contracts. Before I hand the mic over, I have a few housekeeping items to cover about the presentation. We request that you put your microphone on mute to avoid any disturbance during the webinar. Next, we'd love to hear from you during today's presentation. If you have a question for our speakers, please feel free to type that into the questions panel on the control panel. You may need to send in, you may send in your questions at any time during the presentation, but we'll only answer it towards the end of the session. Once you leave today's webinar, you will receive a survey on the presentation, and we would appreciate if you could provide feedback. Without any further ado, I'd like to kick things off by welcoming up our panelists for today. Richard, over to you.
Thanks very much, Preetha. Let's just check that Alex and Tim are on the line. Are you both there, gentlemen?
I'm here.
We seem to not have Tim. Oh well, hopefully he'll be able to join us soon, and otherwise I'll get him on my mobile and we'll deal with it that way. So more housekeeping, sorry about that. Let's go to the first slide. What are we trying to do today? So essentially, members are telling us that they're concerned that contract conditions in the industry are creating unfairness and are adding to commercial pressures. And we've made that point very strongly to the National Transport Commission, which is involved with an overall review of the heavy vehicle national law. And what we've said to them is it's difficult to engender a safety culture when you have those terms and conditions which are quite harsh and which we say are unfair in some contexts. So one of the major protections in place for small business and consumers at the moment is the unfair contracts law. What we want to do is explain the law to you at the moment, tell you why we think it's deficient, because we've written to the government to say that, and to urge members to check their contracts through NatRoad and to have their insurance broker look at any proposed contract before you sign it and lock it in. So the unfair contract terms law is not the only area where there is protection, and so I want to start by telling you about where NatRoad examined a contract for a member recently as part of our regular service in order to assess their contractual obligations before they formalised that contract. So that contract, in my mind, raised the question of whether or not Section 26E of the Heavy Vehicle National Law is going to be invoked by the authorities. Now, that section deals with prohibited requests and contracts under chain of responsibility. So essentially it says that a person can't ask, direct or require or enter into a contract with the driver of a heavy vehicle or any other party in the chain if it means that that person knows, and quite reasonably, ought reasonably to know, that it would have the effect of causing the driver or the other party in the chain to breach the speed limit rules, the fatigue rules. Now, under the particular contract we looked at, the NatRoad member would be liable for undefined, missed, delayed or futile services. So our member would be liable for the prime contractor's costs for those services, would not be entitled to be paid for them, and would be required to perform the services in any event at a later date at a time set by the prime contractor. A key to these so-called missed and futile services was set out in a schedule to the contract, where one of many so-called key performance indicators required the company to contact the prime contractor prior to the very narrowly defined time slot or date for the book service to be delivered, and give a detailed plan for rescheduling the next slot delivery. This provision was to be applied against, as I said, a very tight timetable for delivery of the goods. Now, the consequences for breaching the so-called KPI are extremely harsh, inclusive of our member paying for the cost of delivering during the prime contractor's nominated time slot if the company couldn't meet the initial delivery schedule. The KPI operated even though there was a further open-ended contractual requirement for the company to have its vehicles wait at the relevant site for such time as was required for the truck to be loaded or unloaded. Failure to meet that KPI and many others meant that the company would have to pay a penalty, albeit it was described as agreed liquidated damages, when those KPIs weren't met. Those fines and the requirement to meet strict time slot allocations sets the tone for a culture that is both oppressive and detrimental to safety, and raises the question in the mind of NatRoad as to whether or not the authorities will consider taking action under Section 26E of the Heavy Vehicle National Law. Now, in that instance, the current unfair contracts law, which is illustrated in the next slide, didn't apply because this law set out in Schedule 2, Sections 23 to 28 of the Competition and Consumer Act only applies to contracts entered into by consumers or by small businesses who employ fewer than 20 people. And the company that I mentioned in that first example employed more than 20 people. And in relation to other thresholds, the upfront price payable under the contract can't exceed more than $300,000 a year, or more than $1 million if the contract is more than for 12 months. So the other provisions that are mentioned in the slide that that are relevant is that you are signing a standard form contract. That is one that isn't open to negotiation, or you're signing a variation to a contract after the start date for this law, which is the 12th of November 2016. Other issues in relation to the problems with the unfair contract law, first of all, a term would be declared unfair only by a court, and only if it can be established that a term in a contract where you qualify, as I previously mentioned, will result in a significant imbalance in the parties' rights and obligations. And so every single contract in every context has to be looked at. There's no blanket unfair contract term. Secondly, it's not reasonably necessary to protect the legitimate interest of the party who would be advantaged by the term. And so you've got to show, you've got the onus when you're challenging it of saying it's not necessary for the operation of the contract. And thirdly, it would cause detriment, financial or otherwise, to a party, the small business party, if it was relied on. Ultimately, only a court, as I said before, can decide whether a term is unfair. So the other issue there is the court looks at whether or not the term was transparent and able to be understood by the small business or by the consumer, rather than being surrounded by legal jargon. Was it set out in simple terms? And there are other provisions there in the law which say that certain contract terms are excluded from these provisions, and one of them is the upfront price payable under the contract. That is the amount the consumer or the small business is paid or agrees to pay under the contract for the supply of the services. So all of those things mean that it's a difficult law in the current context. What do we want? What do we want when we've gone to the government to have these laws changed? Well, we want reform that will mean that if an unfair contract term is included in a contract, then penalties will apply, and it would mean that you didn't need to go to court every time you wanted to challenge what was an unfair contract. Unfair contracts certainly don't permit appropriate safety cultures to develop, and it's only when customers view the freight task as integrally involving the operator rather than simply getting the lowest possible price that safety is advanced. So that's one of the reasons we've said to the government, change the unfair contracts law. So even though we've said that to government, even though I've pointed out some of the inadequacies of why it's not used more frequently, the ACCC has had success in taking some companies in the transport business to court under the current law, because the ACCC also has rights to go to the court. And indeed, the very first test case that the ACCC took was against a large waste management company, JJ Richards. And the subcontractors had to sign a template provision with the customer that reflected all of these matters, so that the contract was held by the court to be unfair in 8 regards, and each of those is set out in this slide. And if you find any of these kinds of provisions in your contract, remember that you're able to challenge them, or at least complain to the ACCC and get NatRoad to look at the contract if these provisions are present. So the first one, it said that you are going to enter into another contract with us unless you cancel the current contract within 30 days before it ends. It enabled JJ Richards to increase its prices unilaterally, that is, without reference to the customer or the subcontractor. It removed any liability for JJ Richards where its performance is prevented or hindered in any way, something along the lines of that contract that I opened up with, that we assessed for the company that wasn't able to shelter under the unfair contract terms law. Allowing JJ Richards to charge customers for services not rendered, even when caused by reasons beyond the customer's control. Again, that's resonant of the provision where if you missed your 15-minute time slot, you had to go back and deliver and not be paid for that delivery. Giving JJ Richards exclusive rights so that it prevented them entering into another contract, allowing them to suspend services but to continue to charge if payment wasn't made within 7 days. And very important for today, creating an unlimited indemnity in favour of JJ Richards. In fact, meaning that the customer or the subcontractor became the insurer of JJ Richards, and preventing customers from terminating their contracts if there was any money owing to JJ Richards. So what I next want to do is go through what we consider to be an indemnity provision that we're seeing a lot of. I want to emphasise that that over the next 3 slides, we're dealing with an actual contractual provision that is being used in the environment. And if you come across a provision like this in your contracts, we strongly suggest you seek a modification of, or at least a costing from your broker, if insurance can be extended. And whilst it's not the most riveting or entertaining form of communication, I want to take you through each provision. I'd like you to note that if clauses 19.3, which we'll come to, and 19.6, which we'll come to, aren't present in an indemnity provision like this, then it's what's known as a hold harmless provision in its entirety, and you're unlikely to get any insurance for it at all. So let's start by looking at clause 19.1. Basically, it says that you as the contractor, the operator, provide the services and enter all of the sites from which you will collect goods. You enter at your own risk. Now that contradicts chain of responsibility liability, so you need to be aware of that. And also, if you've got subcontractors yourself, you've got to make them aware that they enter these sites at their own risk. Now that's something that insurers may well seek for you to have modified, and you may well seek to ask the person imposing this provision on you how they intend to apply chain of responsibility to a provision of this kind. Secondly, you as the operator are responsible for any loss, damage or theft, and the materials or products are defined basically as anything that you collect for delivery, transported by you from the time that you start the services until the time those goods are delivered to and received at port. Now obviously I've taken this indemnity from a contract which required an operator to deliver goods to a port. The question that is raised by this provision is, what documentation are you going to have in place to show that you delivered those goods in a condition that wasn't damaged, all of the goods were delivered, and you have proof of that about the time, because otherwise you'll have a continuing liability and you could get into all sorts of arguments. So 19.3, of which I spoke earlier, is an important provision because XXX here is the customer or principal contractor, is not liable for any loss or damage to vehicles or equipment owned by the contractor and used in the provision of the services unless they cause that damage by their negligence. So you're not fully insuring your customer or principal contractor. In the absence of clause 19.3 and given the other indemnities in this contract, you would be acting like the insurer of the customer or the principal contractor. So next is the nub, the central component of the indemnities that you're offering by signing this contract. And any loss or damage to the materials or products, that is the goods, while they're in your custody or control. Again, it's important to have documentation to show when they came into your custody or control and when they left your custody and control. Any loss or damage to equipment or property owned or in the possession of the customer or the principal contractor. Any loss or damage or destruction to any property. So, you know, it's a very broad indemnity. Any personal injury to or death of any person, any breach of the contract obligations. So they don't even need to prove that you've breached the contract. They can just go straight to this indemnity alleging breach, or any negligence that is alleged that you have effected in relation to the provision of those services. And it extends to not only acts or omissions on your part, but any information or advice you give. So you may well need to talk to your insurance broker about whether or not that means you need professional indemnity insurance. Moving on, so 19.5 says that these indemnities that you give, you acting like the insurer of your customer or principal contractor, extend beyond the time of the contract itself. So allegations can be made about a breach of the indemnity under this contract, even though the contract's come to an end. Next, this is reinforcing clause 19.3, and as I said, if this 19.6 or the 19.3 are not in the indemnity provision, then that's a complete hold harmless clause, and you are acting as the insurer of your customer or principal contractor. So that this clause says that the liability under the principal indemnity provisions is reduced by the extent to which the customer or otherwise is negligent or misconducts himself. Absolutely essential provision. And finally, 19.7, the contractor acknowledges that that's you, the operator, acknowledges that the customer or principal contractor can claw back or set off any monies payable to the contractor under the contract if they claim that an event has happened under the indemnity, so that they've got the upper hand. If they say that you, for example, damaged a trailer belonging to somebody else while you were on site, they could claw back, say, the $10,000 worth of damage that they allege you committed when you hit that trailer, and then you would have to prove that it wasn't you, that it was somebody else, because they've got your $10,000. So a very important provision. So the next slide talks about checking with your broker. So let's check in with our insurers and brokers for the advice that they might have based upon our going through that indemnity provision. So can I start with our friend Alex from NTI.
Hi guys, how's it going? Some really great points raised here, and you know, I see any number of contracts come across my desk on a weekly basis, and they have varying levels of indemnities in favour of principals or customers, some of which might be fair, and they might include some of those limbs that 19.6 and 19.3 show, where effectively the principal or the customer is responsible for their share of any potential loss or damage. And other ones we find don't tend to have those proportional liability clauses attached, and they effectively cause our clients to be held 100% liable for any kind of loss or damage or injury that might arise, whether or not our customer is actually the one that's responsible for the cause of that loss or damage. So it's very important that you discuss with your insurance broker, your legal advisors, you know, somebody like NatRoad, to review those contracts to make sure that whatever the content of those contracts is, it aligns with what your insurance coverage provides, or if it doesn't align with what your insurance coverage provides, that potentially your insurance broker can negotiate with your insurer to try and get some cover extended for you. So I don't know if Tim's available on the line, whether he might have something to say.
Yes, yes,
Alex,
Tim.
can you hear me, Richard?
Absolutely,
yes,
yep.
We might turn you up a bit, Tim. Yep, okay,
yeah,
go.
Fantastic. Well, look, sorry about the delay getting on, but you're spot on, Alex. And as you said, Richard, very well articulated. And outside the commercial contract discussion, the insurance contract discussion is very, very important. And if you look at clause 19.3, as you highlighted, the last sentence, unless and only to the extent the damage was caused by the negligence of the ex or its representatives, is paramount. These days we're finding that and or proportional liability is being excluded from contracts, and without it being passed on to your insurer for them to review it or accept it, it's leaving our customers very well exposed. So the key is more and more today, because of the way contracts are being broadened, to absolutely pass them on to your insurance broker or your insurer, so you can have them review them, sign them off, and if not acceptable, help in having them renegotiated to make sure you're not taking on too much of the risk.
Very good advice. Thank you so much. So that really reinforces what the slide is saying. If you come across a provision in a contract which requires you to give an indemnity rather than for you to take out an insurance policy, then have that contract assessed, have it assessed by your broker, have it assessed by NatRoad on a fee-for-service basis, and we can help you manage that particular risk. So that's our message for today. What did we hope to achieve, and have we achieved it? Well, first of all, we ran through the unfair contract terms law, showed why it's currently inadequate. We've asked the government through the Assistant Treasurer to accelerate their review of the unfair contract terms law so that there's a penalty for unfair contract terms appearing in contracts, and they are declared void because they're unfair, rather than having to go to court on every instance. I mentioned in passing that also we want the authorities to test out Section 26E of the Heavy Vehicle National Law to define the boundaries of these prohibited requests and contracts that are proliferating in the transport industry at the moment. The ACCC have taken a few test cases in the unfair contract terms law. The majority of them have been about contracts in the transport industry, including the one that kicked it off, the JJ Richards case, which we referred to. And as this slide says, small businesses don't have the resources to take potentially unfair contracts off the court at every instance, particularly as the filing fee in the federal court alone might be your profit margin. And always, always check with your broker, insurance company before you sign a contract, not only where you're required to give indemnities, but where it specifies what insurance you must effect, particularly if the contract says it's got to be in joint names. So you may well be left without insurance cover if you sign a contract that has those broad-based indemnities. NatRoad does offer a contract assessment service. We're happy to talk about that. So I'll just throw back to our friend Alex from NTI. Do you have anything further you'd like to add?
Yeah, you raise a really great point there at the end, which is that our clients, our mutual clients here, need to be very careful when they enter into a contract. And I understand that it can be a lot of commercial pressure to just sign on for something, but potentially there's a lot of liability policies, and including, you know, motor vehicle policies where you've got liability for property damage arising from the use of that vehicle, that actually have exclusions around liabilities being contractual liabilities that are over and above the ordinary liability that might have attracted in the absence of that contract. So where clients are signing on to agree to indemnify a principal or a customer or another party, and in the absence of that contract, they wouldn't have been obliged to do so, it could be the case that their insurance doesn't necessarily respond. So it's really important that they speak to their insurance broker and get some legal advice on the contract before they sign it, to give everybody the opportunity to assess it and see whether there's something that can be done to help extend some degree of cover. And they may very well find that their ordinary liability cover, for example, doesn't extend to those contractual liabilities whatsoever, or it may give some portion of cover. But potentially your insurance broker may be able to, and particularly again, you know, I'm looking for those proportional indemnities that sort of outline in the contract that our insured is only responsible for their share of any loss or damage, and that the customer or the principal is responsible for their share, where we may actually be able to extend the cover in some way, maybe for an additional premium or potentially subject to a higher excess or something like that.
Thank you. Tim, did you have anything you wanted to add?
No, I think between the three of us, you've covered it all.
Oh, well, thank you so much. All right. Well, now we're happy to take questions. I think, Preetha, we've got one already. What's the question that you have there, please?
So one of the questions we have is how much does it basically cost, you know, with NatRoad to kind of get your contract assessed or reviewed, basically? Okay, well, it's $150 an hour plus GST. It depends on the size of the contract, how many hours it would take. Generally, for a larger contract, it would be 3 to 5 hours, and we give you a written memorandum with identified risks, and we always say in that memorandum, please ensure that the contract is checked by your insurance broker. Thanks, Richard. If any of the participants have any questions, you could just either raise, like I said, put it in the questions panel, or unmute to ask any questions that you may have.
Tim Whitlock.
Yep, Tim.
Just to follow on from the cost structure that NatRoad has just highlighted, if members wish to have their contracts run past their insurer or their insurance broker, usually there wouldn't be too much of a charge for that in first instance, just to check to make sure the contract's right. If an insurer agrees to accept the terms of the contract and provide the indemnity as it is, then that's usually just put back in writing and it could be done as free of charge. It's only when it starts getting a bit more complicated and the advice from the insurer or the broker would be the contract's far too broad and unacceptable is when you would start needing to seek that advice for modification.
Thank you.
If it helps members.
Thank you. I don't think we have any other questions from our 20-odd attendees. So
I think Vivian.
Vivian, oh good, Vivian, yes.
Yeah, Vivian, you could go ahead.
Vivian, do you want to speak? She's put up her hand and we're just waiting for her to ask her question.
Oh, you do have.
Here we are.
We have plenty of questions.
Here we go.
We'll start with one.
The issue of contracts is usually on a deadline basis. Can you sign a contract and hold a particular clauses to be modified, etc., at a later date? That would depend on the terms of the contract. You could actually start effecting the services on one basis and have the rest of the contract terms subject to negotiation. The law is quite clear that you can have what are known as conditions subsequent to the effecting of a contract, that is, conditions which apply after the services are started. So we would help you with that. Next question, is it fair or usual for a contract to have a clause, either party may cancel the contract for any reason by giving 28 days written notice? This effectively turns a set term contract into a maximum end date agreement. Well, there's some issue legally about whether or not the contract ending by one party giving notice is fair or unfair. Where that obligation is based on a mutual condition, that is, either party has that right, then it would be, under the current law, even if you are a small business, very unlikely that it would be considered to be unfair. And yes, we are able to help you with a provision of that kind, but you're right. It effectively means that even though you might think you've got a contract in place for a year, it's a month-to-month contract with that running. The other thing about notice, I must say, and provisions of this kind, is I've seen a contract recently where you effect it for 12 months, but there is no obligation on the part of the customer or the principal contractor to give you any work. So you sign a contract, you allocate the resources, but then they don't give you the work under the contract. So that's one of the other reasons we should assess those contracts for you. Next question, are we able to get a copy of the slides? Yes, Vivian, they will be uploaded onto the NatRoad website and you can review them at your leisure, and you can ring us if you're a member and we'll answer questions about it. Next one, we just had a 5-year contract cancelled after 11 months, leaving us with 4 years of vehicle leases. Small business contracts only apply to under 20 employees or 1 million. This dollar limit would hardly pay wages. This protection is moot. Can you look at increasing the dollar limit?
Two different questions, sorry.
That's okay. Well, we're asking the government to examine the. Oh, I see, they're two different questions. Sorry. Yeah. But look, I've rolled them into one. Certainly, if outside of that contract, in respect of the member who leased vehicles for 5 years and then the contract was terminated after 11 months, you could look at whether or not the person who cancelled the contract did anything that was misleading and deceptive under the competition and consumer legislation that meant that you took out that lease and you may well be able to get some damages back for those monies. The question about the $1 million, yes, the unfair contract terms legislation is currently inadequate, including that particular provision, which is why we've asked the government to review it, and hopefully that review will take place shortly. And then the final question we have, can NatRoad help us with writing up contracts for our customers for accounts receivable payable? The answer is most likely we can. It depends. If the customer is another NatRoad member, then we don't act. Obviously, we've got a conflict of interest, but otherwise, yes, we can assist with most contractual matters. So, thank you for that comprehensive list of questions. Feel free to ring us anytime. There's a final question. Where are we at with the 30-day payment provision? Okay, so NatRoad policy is to have 30 days as a maximum payment. Yesterday, we lodged a submission to a Senate committee inquiry reinforcing the NatRoad policy that this be encapsulated in the law. And what we want is a code of conduct under the competition and consumer legislation, a code of conduct which would make it unlawful to pay beyond the 30-day period, and also make unlawful pay when paid provisions, so that subcontractors would only get paid if the principal contractor was paid. So we've put that before a Senate committee. We've had that request knocked back by the government now twice under two different treasuries, but hopefully reinforcing the fact that the Small Business and Family Enterprises Ombudsman has recommended that, and also putting it before a Senate committee will reinforce that that is an appropriate thing to undertake. So I don't think there are any more questions. No, we're just checking the technology. We'll give you a few more seconds. No? All right, well, let me thank again our panelists from NTI and AEI. Very much obliged. And do they have any final words or any answers to the questions that I might have overlooked? Tim?
No, just to remind all members, we're proud to be here to support NatRoad and its membership. And if anybody has any insurance contract questions, by all means, feel free to call me or the team.
Thank you. And Alex, are you still there? I'm not sure that we've got Alex. Maybe we do. I'd like him to have a final word.
There we go. There we go. Yeah. No, thanks again. I think it's just really important to remind all the members that when entering into a contract, there are insurance provisions they need to be mindful of, and the services of a good insurance broker and an insurer can't be overlooked in terms of entering into those contracts.
Wonderful. All right.